Welcome to the South Carolina Probate Court. The purpose of this video is to provide you with a basic understanding of the probate court system and the process of estate administration in South Carolina. Probate court is a specialized court that oversees estate and trust administration, adult guardianship and conservatorships, marriage licenses, and mental health proceedings. In South Carolina, probate judges are unique because they are elected by the people in each county, and they serve 4-year terms. In South Carolina, each county has a separate probate court. Although the law is the same that governs all probate courts in South Carolina, there may be some specific procedures within each county. Before filing in your county probate court, please check to see what differences there may be. In addition, county probate courts sometimes provide forms and other information on their websites. Local judicial staff at your county probate court can help you navigate the website and assist you with these resources. However, please keep in mind that court officials and court clerks cannot give you legal advice or advise you on how to prepare legal documents. The law allows you to represent yourself in probate court. However, the laws and rules that govern probate courts can be complicated. Only an attorney can properly advise you of your legal rights, provide legal counsel, and act on your behalf. To protect your legal rights, you're strongly urged to consult an attorney. This video is not a substitute for legal or accounting advice. You should consult a local probate attorney in your county to help you with detailed questions. If you would like assistance finding a licensed probate attorney in your county, please contact the South Carolina Bar's Lawyer Referral Service at 1-800-868-2284. The following scenario is intended to provide you with an introduction to probate court and to help you feel more comfortable with the estate administration process in South Carolina.
Hello, my name is Judge Deborah Faulkner, and I am a probate judge in South Carolina. You're probably asking yourself, what exactly is probate? Probate is a legal process that takes place after someone has died to determine how his or her debts will be paid and how the assets will be divided. The way you probate an estate depends on whether your loved one died with a valid will. If your loved one died with a valid will, your case involves a testate estate, and the deceased person who wrote the will is known as the testator. If your loved one died without a will, then the state law controls the administration of the estate, including how the assets will be divided and distributed after the payment of debts and expenses. If your loved one died without a will, your case involves an intestate estate. Probate proceedings may either be informal or formal. An informal proceeding is for estates in which you do not think anyone will challenge the terms of the will or the administration of the estate. You believe the administration of the estate will be smooth sailing with little involvement from the court from beginning to end. In informal proceedings, you will not have an actual court hearing unless one is requested. In contrast, a formal proceeding involves a formal hearing before a probate judge to determine whether the deceased person left a valid will. A formal proceeding can also be used to determine who should be appointed as the personal representative of the estate. A formal proceeding is started by the filing of a summons and petition with the probate court and serving these documents on everyone who may have an interest in the estate. Some examples of disputes that may require formal administration are someone wanting to be included but was left out of the will, there's not enough witnesses to the will, or there are improper marks or notations on the will. In formal estate administration, every detail is closely supervised by the probate court by way of notice to all interested parties. Once you determine if your estate is formal or informal, you must complete and file either an application for informal probate of a will or a petition for formal testacy with the probate court. If a petition for formal testacy is filed, a summons must also be filed. Some forms can be found on the South Carolina Judicial Department's website. www.sccourts.org. These are listed under Court Forms. In these videos, we will follow a widow as she deals with the death of a loved one and attempts to navigate through the probate process with the help of a lawyer. In this video, she will begin the process of opening her husband's estate.
Well, I'm sorry to hear about your loss, ma'am. Please come in and have a seat. Well, I can certainly help you with your estate issues, but please allow for me to introduce myself. My name is Bruce Smith, and I am a probate attorney.
It's nice to meet you. My name is Louise Carter.
Louise Carter, nice to meet you, ma'am. Now, see, you've brought some paperwork with you, Miss Louise?
My husband did leave behind a will and some paperwork, but I'm confused and I need some guidance.
Let's start with the will. You have the husband's will here?
I do.
Okay, this is a great place to start, so let me look through here. Now, do you have the death certificate as well, ma'am?
I just received it. It actually is in the folder.
Okay. I see it here. Well, good. It looks like we have all of the documents needed to open a probate estate.
In South Carolina, the probate process usually involves 3 steps: opening an estate, the administration, and closing the estate. Opening a probate estate provides essential information to the probate court, such as information about the deceased person, the name of the interested parties, and information about the estate. When you open an estate, the probate court will need the original will and proof that the person has actually died. The best evidence of this is a death certificate. However, if a death certificate has not been issued, court staff may allow other evidence, such as a coroner's report or newspaper obituary.
How do we open my husband's estate?
Well, we have to file the will in the county in which your husband lived within 30 days after his death.
Can you walk me through it? I'm a little confused and I don't understand some of the language.
Of course. But I do need to ask you a question. Now, is this your husband's original will?
Yes, it was in the safety deposit box.
Okay, because the courts will need the most recently dated.
No, my husband was very organized and we discussed that this would be the only copy and that we would place it in the safety deposit box.
And you've not found any other copies or any other wills?
No.
Okay. And I do see that this is the original will. I see the seal now. Okay, well, why don't we take a closer look at the will, and you and I will just walk through it together, okay?
All wills have certain basic components. The opening paragraph of a will usually contains standard language with specific wording that must be used in South Carolina. The first paragraph usually addresses debts, and the next paragraphs are usually the conveyance clauses, but every will may be organized differently. The conveyance clause is how we determine who actually inherits something. These people are called devisees. A devisee is just a fancy term for someone who receives a gift under a will. The will usually identifies the name of the personal representative, or PR. A personal representative is the person who administers or settles the estate. The personal representative has a duty to abide by the law and settle and distribute assets according to the terms of the will. The personal representative also has a duty to act in the best interests of the estate. In addition, some documents may be attached to or found with the will. For example, some wills may have a document attached to it that amends it, called a codicil. A codicil is usually a short document that changes something in the will, such as the name of the personal representative or how the property is divided. A codicil must be in writing, signed by the testator or at his or her discretion, in front of 2 witnesses. The best practice is to also have the codicil notarized. A will may also have a memorandum attached to it that specifies how tangible personal property should be distributed to friends and/or family. This memorandum is meant to list how sentimental items like heirlooms, collectibles, furnishings, and jewelry are passed. This memorandum either has to be in the testator's handwriting or signed by her or him. The best practice is to have the memorandum signed and dated by the testator. The personal representative must divide the tangible personal property according to the memorandum. If the personal representative does not find a memorandum within 90 days, then it will be assumed that one does not exist, and tangible personal property will pass according to the terms of the will.
Well, it looks like your husband named you as the personal representative, or the PR. Now, this is an important job, and I can explain to you what this job is.
Well, I just hope I can do everything. You know, I'm a retired school teacher and I'm very organized, but I just don't want to make any mistakes.
Oh, don't worry, ma'am. I'm going to walk you through this and we're going to get through it. Okay? Now that your husband's will, it's good. It looks to be valid. I see that he signed it. 2 witness signatures here, and it's been notarized.
I'm just glad that John had a will and that these details were spelled out. And I'm glad we talked about these things before he died.
A will is a very important document, and everyone is encouraged to get one regardless of the size of your estate. Having a will makes probate process much easier. If you do not have a will, you can't determine who will get your things or how your estate will be managed. A will allows you to divide your probate assets or possessions the way you want them to be divided. If you die without a will or intestate, the law controls how your probate assets are divided. After the debts and expenses are paid, the remaining estate is distributed to your heirs as determined by South Carolina law. For example, in South Carolina, if you die without a will and you are married with no children, then your spouse would get all of your probate assets. If you die without a will and you have a spouse and children, your spouse would get 1/2 of the probate assets, and all of your children would equally divide the other 1/2. In an extreme case, if you die without a will and you do not have a spouse, children, or other blood relatives or stepchildren, then your probate property goes to the state of South Carolina, specifically the Department of Revenue. These are just a few examples. Intestacy laws are complex. If you would like for your probate assets to be divided in a certain way, you should have a will.
Since I am the personal representative, what do I have to do?
Well, the personal representative has a lot of duties. Okay, but first and foremost, we want to make certain that we adhere to all of the rules and regulations of the court. Now, there are a few deadlines that we have to adhere to, and we want to make certain that we look out for anyone associated with the estate, including creditors.
Okay, well, what do I have to do first?
Well, first we need to file the will, the death certificate, and the application for appointment with the probate court. Now, you may be asked to pay a filing fee at this time, but once you receive the certificate of appointment, you will be able to care for your husband's estate.
Well, what exactly happens after I get the certificate of appointment?
Well, once you receive the certificate of appointment, this is when the probate court's deadlines start to run.
I hate deadlines. What do I do first?
Well, there are a few people that we need to notify first.
The personal representative has a responsibility to provide notice to certain parties, including creditors and heirs at law. The notice must indicate who has passed away, the personal representative's name and address, the date of the will, and the address of the probate court. This notice alerts interested parties to the fact that someone has passed away. These parties may want to challenge the will or see the probate file, which is a public record. The cost of the notice is an estate expense. The personal representative is also required to publish notice to creditors in a local newspaper. In some counties, the probate court helps the personal representative meet this publication requirement by running an advertisement in the local newspaper for them. Please check with your local probate court for their procedure. The cost of this advertisement is an estate expense. Once the advertisement has run for a period of time, creditors must file a claim against the estate. If they do not file a claim, they will be prohibited from recovering.
Now, we must provide notice to the creditors by running an ad in the local newspaper. Now, creditors usually have first rights to probate assets.
Well, thank goodness my husband didn't have any debt.
Well, even so, ma'am, running the ad in the local newspaper is required by law.
Well, I'm glad you know all this, but I'm having second thoughts. What if I don't want to be the personal representative? I'm afraid that I might not have enough time to get it all done, and I think it's overwhelming.
Well, if you don't want to be the personal representative, you can always complete a renunciation form.
But I don't want to give up my right to inherit.
You won't give up your right to inherit. The renunciation form just informs the courts that you'd like to appoint someone else as the personal representative. And the will may even name an alternate.
Well, John named me as the personal representative, so I suppose I'll do it for him.
Well, that's great. And don't worry, I'm going to help you out throughout the entire process.
If the will authorizes the personal representative to sell assets, the personal representative may sell real estate for fair market value, subject to the best interests of the estate and beneficiaries. But you should review the powers of the personal representative very closely. These responsibilities are usually found in or near the paragraph in the will that names the personal representative. It is a good practice to wait until the creditor's time to file claims has expired before selling real estate. The personal representative has a duty to protect creditors, not just the heirs or devotees. This is why some probate courts discourage personal representatives from selling real estate until that time has passed. If there is no power to sell assets in the will, and if it is necessary or desirable to sell the real estate before the estate is closed, then the personal representative must go through a formal estate procedure and ask the court's permission to sell the property. The court will want to know what you think the property is worth and how much it might sell for if it is sold. In addition, interested parties will have to be given notice of your request to sell the property.
Great. Well, those are my only questions. I suppose we need to schedule another meeting.
Yes, we do. And the next thing we need to do is to find out what your husband owned and the value of what he owned at the time of his death, so that when we do meet again, we can complete an inventory and an appraisement.
Okay.
I know it sounds like a lot, but don't worry, Louise. I'm going to help you throughout the entire process.
Well, I'm ready to get started. Now, what do I do first?
Well, I'm glad you asked. Now, you did tell me you were a retired school teacher, right?
Yes.
Well, great. How about next time we meet, you complete this homework. Now, this form will allow for us to complete the inventory the next time we meet.
Well, it's been a long time since I had homework, but don't worry, I'll get it completed.
Now, this is a lot to remember. Probate lawyers and judges do this work on a daily basis. If you have questions about how to proceed, you are strongly encouraged to consult a local probate attorney in your area or visit your county probate court. Remember, only attorneys can provide legal advice.